So thank you so much to all the people who have joined us today. So it's a great way to kick off the month of February. So today we are here for this online event organized by the ICCJ, the Institute for Criminology and Criminal Justice here at Queen's University Belfast, in collaboration with the research cluster on European and transnational law. So I would like to acknowledge and thank my colleague Billy Merlo Araujo and Alessandra Guida, but above all, Professor Jacob Öberg from the University of South Denmark, who will be presenting his forthcoming book titled The Normative Foundations for EU Criminal Law, Powers, Limits, and Justifications, which will be coming out in June, open access with art. So we are absolutely delighted to have Jacob with us today. So the format of this event will be as follows. So Jacob will present for roughly 40 minutes. Then I will serve as a discussant, asking him a couple of follow-up questions. But then we do want to have a lot of time for Q&As. So with no further ado, I will leave the floor to Jacob. Thank you so much again. And we truly look forward to hearing your thoughts on this very, very topical issue. Thank you so much.
Yeah. Thank you, Alessandro. That's a very nice introduction of you, and thank you, Billy and Alessandra as well for organizing this. And Queen's University Belfast, it's a pleasure to be here and to at least online to speak about this, because I mean it's kind of like a big project that I've been working on for quite a long time. I think probably some of the ideas here probably started 3-4 years ago. Before I actually started to talk about the book, I want to explain a little bit how this process of writing a book goes a little bit, because I think that can also be interesting. I mean, this is a big this is actually the final sort of outcome of a research project that I got funding from the Swedish Riksbankens Jubileumsfond, which is the Swedish Riksbank, one of the big funders in Sweden. They gave me a sabbatical grant to complete the book, which is kind of like a 1-year grant where you are kind of cut off completely from teaching and administration, and then you're actually able to sort of sit down and dig and do proper research. And I basically just submitted a proposal for them, really short one, and then also I took contact with Hart, and they were interested in publishing the book as well. So I think this is like a really and during this period I also did some other projects on the side with Valsamis Mittilegas. We did a special issue in the European Law Journal on the kind of this bit same topics, and then I realized that there is actually people who have different views on this. It's very interesting, because I thought that this was kind of like what I was saying was going to be like the mainstream view, but it wasn't really. Like all my other colleagues have completely different takes on this, so it was a very interesting project to work on. So I think this is kind of like a thing that has been like a bit going on for quite some time. And I published a couple of articles some years ago in both the European Constitutional Law Review and the European Law Journal, where I started to think about justifications more generally for EU criminal law, and is there really a justification for this kind of like field. So that's a bit of a background to this project, which I'm kind of like now. And I'm also like a bit like curious what people think about the book, because it's really, I think it's quite short to be a book, and I wonder whether it's actually going to be if it should have been more comprehensive and so. And I think it should have been more comprehensive, but we'll get to later to that, I think. Now I'm gonna see if I can just move this. So the aim of the book was to develop a framework, and that sounds really like vague and ambitious, to assess EU criminal law initiatives, and I would do that based on some type of sort of like theories and like kind of clusters of theories. I would rather say like one, which I would say is like this sort of market failure kind of literature, economics literature, which have been used quite a lot to study, I think, EU integration like, and also I think one of the bases for why we have the EU from the start, like the collective action problem. And I try to also approach the topic from that, like why, I mean, asking why we need EU criminal justice is actually asking why do we need the EU from the start, actually, apart from it being like a peace project. But why is the point of having a European Union like supranational legislature? I think that's also the way, that's my basic sort of premise in the book, to start from that point of view, that we need EU criminal justice to resolve some kind of transnational market failure collective action problem. We can see how we define it precisely. And then I also use some ideas which are linked to that in comparative federalism, a little bit, that literature, and some also I wanted to include because of criminal law, and I was also like very much inspired by my good friend and colleague in Edinburgh now, Stephen Kutz, about this public goods framework for also studying EU criminal law, and see if I could kind of find a framework that actually I could use to review different initiatives at the EU level and different competences, different powers, different agencies. And also I had some idea, I call them representation-based political theories, but I'm not sure what they're actually called, but it's kind of like a strand of theory which has been developed by writers like John Hart Ely, like Alexander Somek, and I think Kristian Jörges. So they also go a bit back on like European integration. So the ideas of transnational interest, we'll get back to that, but that's also a kind of a part of theory. So I'm not sure if one should do things like this and mix all theories like I have done, but at least, I mean, it's something which I don't think anyone has done before, and I'm not sure it was very successful, but still, I think the problem was execution. It sounded very good, the project from the start, but it was difficult to execute it actually on the way, and all these theories didn't actually make sense to assess all kind of like EU criminal initiatives. So that's also what I realized, that, you know, some theories were good to assess certain like parts of EU criminal, but certain theories didn't work that well. So I at least this was a new kind of like way of doing it. But yeah, I'm not sure it was, you know, the execution is always more difficult in my opinion. Yeah. So I mean, first of all, I think we have to think about why do we want to study normative foundations? I think one of the reasons why we want to study normative foundations of EU criminal law is the same reason why we studied in criminal law, because this has been, I mean, not the biggest field in in national criminal law, but it has been some kind of like literature here as well on the basis that, you know, criminal law reflects in a way our deepest sort of ethical sort of convictions, the society's ethical convictions. So the legitimacy in a way of criminal law is the standards of legitimacy are quite high in terms of criminal. So we need to know why do we do this? Why do we do it? Like, and what is a good reason to use EU criminal law? What is a good sounds very sort of vague, but it's really about that. What are the moral kind of like good reasons to use criminal law and EU criminal law as well? And also, I think that it's important because we have a kind of a sort of also politically sort of complex climate in the area of freedom, security, and justice with rule of law challenges and the European arrest warrant kind of cases with rule of law. So we have to think about what is the right kind of balance. I mean, I'm actually not doing that in the book, especially the European arrest warrant, but, you know, we have this kind of like tensions between effectiveness contra rights, rule of law, and what is the right kind of balance there? I think that's also normative. We have to think about why are we doing this and what is the right kind of balance here. So that's also why I wanted to go to check on this topic, and it's also the reason I had to sell this story at least to the funder initially, why I thought it was important. But I think it is important. I think it is increasingly important because I think that we are not thinking enough why we are doing things at the EU level. And I'm one of the biggest pro-EU persons in the world, but we are not thinking sufficiently of convincing reasons why we should have something regulated at EU level rather than national level. We are always like, yeah, let's do something at the EU level, but why? It's kind of like it needs to be some kind of idea behind it. It needs to add value. It needs to be founded on some kind of like idea or reason, like some kind of rational sort of thinking behind it. So this book all speaks about more like rationality in general, I think. So yeah, I touch about legitimacy, and it's basically because, yeah, I mean, both criminal law is kind of like basis for society, it's kind of ethical sort of ideas and all that, but it's also about criminal law, EU criminal law, and I think people sometimes miss this point, has very like, it has very lasting consequences for individuals, because normally using criminal law, especially if you give more powers to Eurojust or Europol or European Public Prosecutor's Office, for example, which I discussed in the book, or if you use more criminalization, for example, which EU is doing at this moment, and like it's really going on a lot at this area actually at this moment as well. The final consequence of using criminal law and in conferring stronger powers on these aims is that individuals will be harmed in a way. Maybe they are in a way, like as a criminal lawyer, maybe think that they deserve to be harmed, but they will get like sanctions. They get higher sanctions normally, not lower sanctions. We don't have decriminalization much at the EU level. We rather have criminalization. We have, because it's kind of a minimum sanctions, minimum rules, which always leads to more repression. So it leads to more repression in society, and individuals will in the end suffer. And you know, criminal law is kind of like, it's the most strict tool in a way we can use in society to kind of to sanction and punish someone. So it is kind of a sharp tool. It is, and I think that we have to think about this, that we actually have to think carefully before we use it, because it's always about like, we have a problem in society, well, let's use criminal law to solve this problem. I don't think this is how things work. And you know, people studying criminology know this, but you know, it doesn't always come across to lawyers and to politicians this point of view. Well, it rarely comes across at that point. And I think this is also that kind of thinking I want to have in mind as well in the book. I mean, the state sovereignty thing, I mean, it sounds so like repetitive to talk about state sovereignty. Well, yeah, it's repetitive also from a Brexit perspective, but let's not talk about that. But like, it's repetitive in the field of criminal law, because yeah, we talked about this for 35 years now in the literature and the debate. Well, why do we still blather on about sovereignty? Well, it's because states are still actually really, by some kind of psychological problem, having a huge psychological problem just accepting that the EU will be involved in law enforcement in general, not having any rational reason why they wouldn't be involved. But for example, the debates on the European Public Prosecutor's Office, which I think is a very good idea to do at the EU level, and there's a good, like, you know, normative justifications behind it. I mean, that's what I write quite a lot about in the book. But the debates on the EU PPO shows that states are intrinsically against having law enforcement at the European level. Well, especially when it comes kind of into like their own jurisdiction, which the EPPO does, which is kind of like a striking sort of phenomenon with the EPPO. But I think that kind of like means that the state sovereignty debate is not over, but maybe it's not about state sovereignty. Maybe it is about, and I think that would be a more convincing way for states to defend it. It's actually more about democracy, maybe. And like that national democracies are maybe stronger than EU democracies in a way. One could maybe argue that way, like the Bundesverfassungsgericht did in their Lisbon Treaty judgment, that this is why you need some kind of extra sort of protection in the field of EU criminal law, and why we can only use it more exceptionally. But I mean, I would normally say that this debate should be over, but it's not. At least not in the state's mind, it's not over. For EU criminal lawyers, we think it should be over, but it's not for states over that debate. So this is a bit about the legitimacy, why it matters. This field generally, I think it matters for these reasons a lot. I think this is really, I think that the scholarship in this field has been kind of afraid of tackling these questions. They've been afraid of going in this direction. It's been sort of like yeah, and I think we are more like going in generally in this direction of actually challenging more the assumptions behind EU criminal law in general. Yeah, so let me say then something about, and I use this kind of like distinction between descriptive and sort of more a normative account. I'm not sure if that's so like coherent, that distinction, but in descriptive account, I would say I mean that these are kind of the justifications that have been used officially by the EU institutions to sort of to defend EU criminal law, the development of EU criminal law. And in this field, and I think this, I'm not the first one who's been writing about this. I think Valsamis Mislegas touched upon this earlier, but I wrote an article a couple of years ago with the late Chris Harding, where we went through kind of these distinctions, and we identified that we have sort of those two principal drivers of EU criminal policy, which I think are well known. One is security in a very broad sense. We use it. The other one is, of course, effectiveness, which is kind of which was behind a lot of developments in other fields of EU law. So obviously, what's going to at some point also happen in the field of EU criminal law. So that was kind of shaping EU criminal law for a long time. It shaped sort of like seminal rulings like the environmental crimes case, the new competence in the treaties in Article 83.2, which I basically wrote my previous book about, and that was kind of like that was shaping that kind of like powers, and I think it's also been shaping very much the design and the ideas behind the EPPO, the European Public Prosecutor's Office, that we have the idea of effectively enforcing, you know, the EU budget, the getting the money from to protect the EU's financial interest. So that's also definitely this kind of like thinking is definitely behind the EPPO as well, I think, as I see it from a certain point of view. And it's also interesting, but I don't think I touched so much upon it in the book, that, you know, these kind of justifications have been used by different institutions. So, you know, the effectiveness justification has particularly been used by the supranational institutions like the Commission, the European Court of Justice, and maybe the Parliament, whilst what we come to now, security has been member state driven, and states have been in charge of that. And the security-oriented rationalis was absolutely, you know, defining at some point in European integration the field of criminal law in the beginning of the 2000s. And it was all kind of triggered by the external event, or 2 or 3 external events, which were the terrorist attacks at 9/11 and in Madrid and in London. And they triggered a number of initiatives in the field of criminal law, where the states unanimously agreed. You know, they have problems now to agree on the EU budget, which is maybe basically just down to Orban. But, you know, they unanimously agreed to a number of initiatives really quickly after the terrorist attacks, because no states were kind of like, it was politically impossible to say no to these initiatives. So they agreed the European arrest warrant, European evidence warrant. They agreed different frameworks on terrorism, and, you know, a lot of different fields. So, and it also kind of triggered the development of these 2 agencies that I'm discussing in the book, the Eurojust and the Europol. So they were also triggered in a way by this security-minded thinking. And what I also identify in the book is that we have post-Lisbon, if you take European integration a bit further after Lisbon Treaty, which is already quite old actually when I think about it, we have another third sort of tenet which most scholars are more happy about, and that's the kind of the fundamental rights-based approach, which I think links to the book in general quite well. But that's justification is basically to strengthen fundamental rights because there's been too much law enforcement, and getting more balance in, you know, the area of freedom, security, and justice, where there's been a lot of focus on security and not so much on freedom and justice. So more justice and more rights, and you can see that in the sort of proliferation, or I'm not sure if that's the right English word, but the enormous amount of legislation adopted post-Lisbon, or when it, relatively comparatively really large chunk of legislation and procedural rights being adopted after the Lisbon Treaty. I mean, I go through quite a lot of them in the book, but it's been like an avalanche of those kind of directives, which I think has been quite progressive in a way, in terms of what the EU generally normally is able to agree upon. But those directives have been quite progressive in the fields of right to information, the presumption of innocence, victim rights is quite controversial. Right to access to a lawyer, another very controversial directive, was finally adopted with a lot of compromises. So, I mean, and I think that's also another justification that we can kind of see. And I think the last one is not, I would say it's in this descriptive account, but the last one is also more normative, I think. The last one, the rights-based justification, is that is a more normative one, which I think is where there is kind of like a clear sort of thinking behind the moral sort of imperative to kind of find a balance and to kind of protect individuals, not only like deter them and sort of punish them. So I think that brings more in line with the rest of the book, actually, that justification. I'm not so sure. How am I with time actually now? I do have some more time, I hope.
Absolutely, absolutely. 20 minutes, please. Absolutely, everything is perfect time-wise.
Oh, okay, perfect. Well, I wanted to kind of like elaborate on everything here when I have 40 minutes, so not going to miss anything. Yeah, well, so then the book really, the ideas of the book, when I identify those kind of like justifications, the idea behind the book is to kind of think about some kind of theory which can kind of like help explaining, and rather not only explaining, but rather justifying, like understand why do we do this. And I start to work with I wanted to find one, but I don't think it's one really. I think there are rather two, theories in playing around here. And I think one is the idea of European public goods, and the other one is the idea of transnational interests. And I don't think they're exactly the same, but I think European public goods can kind of like be fitted in within transnational interest. And transnational interest is the kind of key justifications. And I do find those kind of theories by looking at, other kind of like by looking at other kind of theories on market failure, competitive fairness. But then I'm thinking like, these economic theories, they can to a certain extent explain things, but still criminal law is not only about, effective enforcement and all that. Although I think market failure, collective action theories are important to understand why the EU is doing something. And I think they're well fitted to explain the idea behind why the EU needs to cooperate judicially, to have judicial cooperation, because there's kind of dysfunction in the kind of the systems of extradition and enforcement. So I think there we have a collective action problem that states cannot resolve by themselves, and everyone knows it's a problem. It's kind of gives impunity. So therefore we need kind of like a EU solution to this, which is kind of like the sort of the judicial cooperation mechanisms, like the European arrest warrant and other things. So here I think we have kind of, here it's easier to apply like, more traditional sort of collective action idea behind it. But then when I thought about, for example, criminalization, I thought that I also needed to have a theory which was based on, the criminal law kind of theoretical frameworks, like the harm-based theories or public goods. And I was kind of like, I couldn't really decide exactly which one was the best theory. So I actually tried the harm-based theories in the book as well. And I think that there's good reasons to actually look at both those theories to address why we need criminalization as a background. And I also needed, because it was easy to approach to have the same kind of thinking when I looked at criminalization and the rise of EU criminal justice agencies engaged in law enforcement, because the same kind of thinking behind it. But it was more difficult to align those kind of theories to the field of individual rights, the field of criminal procedure. And there I needed kind of another sort of idea, which I think comes more from the field of free movement, where I wanted to, where I had to throw in this idea of protecting transnational interest and going back to a field of scholarship which was more popular like 25 years ago with Miguel Maduro, Eli, and Jörges and Neyer, which kind of thought that we need protection at the EU level in situations where sort of individuals cross borders because they are not able to kind of access that democratic procedure in that state. So their democratic interest, for them to be taken into account, you need to have sort of an EU sort of EU correction, because states are not able to and cannot like take into account foreigners' interest. That's how I think the ideas was formulated by Jörges and Neyer in an article a long time ago in European Law. So, and I think that framework, which had never been used in that context, fitted quite well into explaining and justifying why we have EU criminal procedure. But that, of course, like that kind of way of thinking also led to some kind of like ideas that we should all led to the idea, which I think is controversial still in many circles, that we should only have protection in cross-border situations for individuals. And I know that many of my colleagues disagree with me on this, but yeah, still that's the view I defend in the book. So I think that's where I come from in like developing this framework, and how I started to think that I cannot use one theory. I really gave up on that in the end. And you always want to have one theory. That's the big thing as a scholar, and that's also how you sell your project on it. But in the end, I think it was more than one theory that I needed here. Yeah. So that brings me exactly to this set of theories that discuss that we need to have some kind of like ideas of transnational democracy. And I'm pretty certain that Somek and Jörges never thought that the theories were going to be used like this. But I think they work quite well. And I think it's kind of becomes, you know, when you look at the sort of the justification, it becomes sort of compelling that we need protection for individuals for other reasons as well. It's like, if you look at the old, like the Kovan judgment from the European Justice in the end of the 80s was about I think maybe he was a British tourist in Paris, and he was attacked and assaulted. And he wanted to claim compensation from the French state, which you could get if you were a French citizen or resident in France. But you couldn't get it as an EU citizen, that kind of state compensation. So he claimed that this was kind of like an obstacle to the free movement of services, because he was a tourist of the service, and he won the litigations. The Court of Justice said that this the right to obtain state compensation was in the same way as other nationals and residents of that state, was kind of like an important part of the free movement of services. And it could not be justified this exclusion of EU citizens from that right by France in any way. And I think that case, of course, not like really connected. Well, you didn't see that in the case, but you can start to think about why do you come to this conclusion? Well, you come to this conclusion because, you know, as a victim in another state, you have less rights, you have less information, you have less access. You're much more vulnerable. You're vulnerable as a victim in your own state, but you're even more vulnerable as a foreign victim in that way. So if you have that kind of like situation, and you know the national democratic process will not take your interest into account for several kind of like reasons, you need to have some kind of correction mechanism, and that's where the EU comes in and kind of try to level the sort of, not the playing field, but level the ground in a way, and give them I think they speak about virtue political rights, but someone challenged me, virtue is the right word really. But anyways, I think it's used in the literature either by Somek or Eli. I think this even goes back to John Hart Ellis scholarship, this these ideas first, that's a long time back. Of course, he had no idea about the EU criminal procedure when he wrote his books, but I think the ideas are a bit similar, definitely. So I think that kind of set of theory I needed just to kind of justify EU criminal procedure, why we have that, and why we also need to limit it, because the justifications that I use in the book also provide some kind of limit and constraint to what the EU can and should do, as also from a normative perspective. See here. Yes, that's a bit like of the argument in the book that I presented, and I wanted also to reflect a little bit on, because I think you can also see this in a different way. And in the end of the book, I speak about it because, and going also a bit back to literature from a couple of years ago when this was studied last time, that you can actually separate and distinguish these kind of theories in more instrumental and autonomous justifications for EU criminal law. And we had a lot of discussions about that in our recent special issue. So when I started working in this field, and I think I did reasonably well in my first book in terms of like developing some kind of ideas of what EU criminal law, the limits to EU criminal law, taking quite a dogmatic approach. But I was always looking at it from like an instrumental point of view, and like very like kind of accepting the instrumental rationale behind EU criminal law. I didn't think about it so much then, but I know Stephen Kutz criticized me in an article at Common Market Law Review. He's my friend, so it's fine. That I was thinking very like simplified, instrumental about the whole field. So about like that, of course, like the EU needs to use criminal law to kind of like to sort of enforce its sort of like objectives. It could be mutual recognition. It could be judicial cooperation. It could be about enhancing political objectives of the EU. But the instrumental rationale for EU criminal law, that was kind of like effectiveness and all that. That was of course like accepted. Then in my first kind of work, I was mostly thinking about the limits of that justification. How kind of like, was it really effective to use EU criminal law, and could I challenge it in some way if, well, based on that it was just not effective? But you can of course also challenge it on the basis that it's a completely immoral account of criminal law, which I think is of course the way to do it, that, you know, it actually doesn't think at all about whether criminal law is a good thing or not. It just thinks about if it is effective. So that's the kind of challenge, that way of thinking. Yeah, so, and then there came, I think that was mentioned, autonomous justification. That was a term I think coined by Anne Weyenberg a long time ago. But she kind of like used that to, or maybe, yeah, I think she used autonomous justification to kind of say that, well, autonomous is kind of like a more kind of self-standing justification that you would use in national criminal law. For example, that something is really harmful to society, it's evil behavior, it's damaging to society, so we use criminal law for that reason. So that's kind of an autonomous justification. Autonomous justification can also kind of be linked to kind of the common values of the EU, and, you know, it gives kind of rise to this expressive dimension of EU criminal law in a way, in my opinion. And I think here we really there's almost like I wouldn't say a clash, but there's a tension between us work in this field, that there are many scholars in this field that would like the EU to use more an autonomous justification for criminal law rather than this more narrow instrumental view. The problem is that I identified in the book, and also I think I identified it in my previous work as well, is that if you use the autonomous justification, you, especially in the role in establishing like a European common sense of justice and all that, you get a very broad, comprehensive remit for the EU legislator, which is kind of similar to the national legislator. And I see a tension here, and you can see it now, particularly in these recent debates on violence against women, and also on hate speech, which are kind of like two much discussed, debated, you know, initiatives, which I discuss in the book as well. But they are definitely away from the more traditional instrumental view of criminal, rather to like some kind of value-based autonomous justification, where the problem is not really the kind of, there's not a really collective action problem or problem at, you know, that these are cross-border crimes. They're not really. That's the thing. They are in general not cross-border crimes. And then why do we do it? Well, then why do the EU legislators do it? Yeah, they do it because they want to solve a society problem which is not the EU's problem really, and they also want to create some kind of values and kind of identity to the EU, that the EU cares about racial discrimination, they care about violence against women, they do care a lot about it, but getting that, you know, sense into like a proper justification for the EU to act, I think it's difficult. It can be a reason for a state to act, but it's very difficult to transfer that to the EU to act. So I'm a bit ambivalent about this approach. It has a very strong political appeal. I mean, to take the practical, this is very practical things. I was heard 2 years ago as an expert before the European Parliament's Libe and FEM committee in a hearing on gender-based violence. And, you know, I just said, you know, as a kind of traditional, boring, dogmatic lawyer that, well, you know, I don't think these are like cross-border crimes, so I don't think it could actually be done with you know, these treaty conditions that you have, the legal remedy that's exists in the treaties. You can maybe use different sort of legal basis, but you know, this is difficult market. You know, that was really, and the MEPs that were involved were highly upset about this and thought that this was completely wrong and that they needed to do it anyway without like a good legal basis. They didn't actually want to listen too much to what I was saying. And this discussion is still going on that I was involved in 2-3 years ago. How do we get here, like even legally? And you know, can be other political objections to it, but it is difficult to just criminalize something which has no, you know, at all cross-border dimension, and you know, clearly not, you know, in line with the treaty sort of remit. So now there is a legal and political discussion among the council, I think, and the commission on the proposal for domestic violence, because they just can't agree on on which crimes should be included, because that's kind of like that's where it comes down to, and it also comes down to what I think the cross-border dimension as well. And so I think these discussions are really kind of exactly where we are at this stage, and I quite strongly believe that we should not pursue these autonomous justifications to drive them all the way, because I think that the legitimacy of the European Union will lose its credibility, I think. And you see this whole book is definitely bordering on politics and policy, because I end up with a lot of, I would say, not fairly legal sort of, you know, well, maybe it's part of a legal analysis, but the end result and end discussion is always a bit politically framed in a way, at least what you want, at least in a way that what kind of EU criminal policy do you want to see? What kind of EU criminal policy would you like to see? So it becomes quite political in the end, the discussion. And I made those points that it's from a kind of more traditional dogmatic point of view. I mean, this flexible approach to using those competences definitely give rise to kind of competence creep, and I think that this might endanger the legitimacy of the EU. On the other hand, I also understand why you want to find, you know, and I think the big discussion point now in the literature and where we are, I'm starting to kind of maybe going a bit in towards my other colleagues in their point of view. It's a big discussion on fundamental rights and individual rights in criminal proceedings, and particularly if those proceedings should be limited to cross-border proceedings or not. And many in the field thinks that they should not be limited to cross-border proceedings, because that gives rise to inequality, it's unfair, it kind of undermines the EU's sort of like idea of area of freedom, security, justice. And I can kind of understand why people want to go in this direction. But it's also difficult to kind of align with the ideas that we should try to protect transnational interests and protect transnational victims, transnational defendants, because they are most vulnerable. So I am actually a bit ambivalent here in the end of the book, where I say that, well, there is maybe some kind of legal argument to be made here, because you have this kind of idea in Article 67 that we should create a common area of justice. And maybe it just doesn't need to be seen in this completely functional, instrumental way, that we can actually have this more, there is a value of creating a common area of justice, and there's maybe a legal argument that you can make that claim, but it's more difficult to align with this idea that it should be transnational interest. So I think that it's still something I'm not completely decided about, which you should of course be, but I'm not, I have to admit. Now I think I'm ending my presentation here, if that's okay for you, fellas, because I think I kind of I mean, I didn't go into all the chapters of the book, but I think the broader ideas of the book is definitely, I have definitely touched upon them, I think.
Absolutely. Jacob, thank you. Thank you so much. And also for this perfect timing, which is absolutely remarkable, and for giving such a compelling presentation. So, as I mentioned, I will act as a discussant for just a few minutes to springboard the discussion, but then really we'll have a lot of time for people in attendance to hopefully ask questions, and we really want to hear much more from Jacob. So I really like the book, and I have to say, spoiler alert, that I'm pretty much in agreement with the arguments being made. I think that the book really speaks to the fundamental question of what should the identity, even more than the remit or ambit of EU criminal justice, be. And as the book really discusses, there is kind of an ambivalence when it comes to the rationales being put forward. And as Jacob noted, the book is very ambitious because it adopts an integrated approach, touching on both criminal procedure and criminal justice cooperations, but of course, as we have heard, on substantive criminalization issues as well. And this is very important because back in the day, before Lisbon in particular, there was this argument, oh, there is a democratic deficit within European institutions. Of course, we cannot go as far as branching into criminal law, because without a proper democratic legitimacy, we cannot really legislate in such a sensitive area affecting fundamental rights and liberties. But then the argument is mostly gone after Lisbon. So we really need to have way more substantive analysis. And there is this idea that perhaps interventions when it comes to criminal procedure and judicial cooperations were easier to justify and sell because they were based on mutual trust as to due process and rule of law standards among the member states. But then I would say that things became more problematic, as you absolutely point out, when it comes to substantive criminal law, because one thing is to talk about transnational and supranational cross-border interests and good. A very different thing, as you pointed out towards the end of your discussion, is to branch out into the idea of building values from above, because that really makes the function and the ultimate goal of European criminal law completely different. One thing, as you said, adopting again a very balanced approach, we should not be tempted to devise a European criminal law that is shaping criminal justice systems within the Union from above, but rather your argument is really that, in a way, we should still we should still be looking at a European criminal law that is supposed to fill voids in a politically integrated space when it comes to, again, transnational and supranational and cross-border interests and goods. You really make a compelling argument when it comes to the role, the space, the ambit, the remit of the European criminal law, because it's really problematic to understand criteria such as security or rights-based justification and rationales as the basis for expanding the criminal justice intervention of the European Union, because potentially, if we go through these kind of catch-all ideas, we may end up very, very easily in a potentially unlimited and unbound reach of European criminal law when it comes to procedures as well as criminalization choices. You mentioned the examples of gender-based violence and hate speech, which are way different, significantly different as compared to, again, the financial interest of the European Union, transnational organized crime, terrorism, corruption, money laundering, and so on and so forth. The idea is really, what is the identity that we want to build for EU criminal law? Do we want to move eventually towards, again, the United States of Europe, and basically there is no other rationale rather than something that affects more than one state, which is the idea that you have for federal criminal law in the US. The federalization of criminal law in the US is based on the interstate commerce clause. And then most of the criminal law is at the state level, is legislated and enforced at the state level. But then the transnational element in the US now is a very feeble criteria, because is interpreted very loosely and basically does not bind criminalization choices at the federal level when it comes to norms and provisions that apply all across the country, and that can be enforced by federal prosecutors in each and every state. So unless we want to move towards that, I think that we must have the kind of conversation that the book really fosters and puts forward. Again, transnational, supranational, cross-border interests and goods versus an expansive version of EU criminal law, be it expressive, I call it in an article, transformational function, like literally shaping values from the top, like a real top-down approach rather than the traditional Durkheimian bottom-up idea of criminalization. Instrumental, so having effectiveness or promotion of other EU values in mind. Promoting European identity, which could be, for example, a rationale when it comes to hate speech. But again, of course, we see that we have many counter-arguments. But again, I think that the book is very, very helpful in shaping the discussion about, and I'll finish here, what the identity, the ambit, the limits, the clear limits of EU criminal law should be, because otherwise we can potentially have again, unlimited reach moving forward of EU criminal law and justice. So I'll stop here. Jacob, if you want to reply to this, otherwise I would be very happy to open up to questions.
I would like to intervene, Alessandro, because that was very helpful, like summary and, really like well argued summary. And I think that actually made me think that I should have written, 6-7 pages more about the federalization of EU criminal law and the federal sort of nature of that, because I think, and I hinted that, but I didn't follow through that much in the argument. I hinted that if Europol is going to turn into a European FBI, you also need to change the whole kind of system, like the whole criminal justice system at the EU level. You need to create your own kind of European criminal law with your own European criminal code, and would have developed like the US, like a federal sort of states. It would also, the EU would have to develop in a different way as well to have that kind of more sort of, to have that kind of federal EU criminal law, and to even accept that, autonomous justifications, because then you need to think that the EU is something different than it is today. And I think that's really what I would like to maybe write about in the future, because now I thought about I should have written about it in the book, and like I think that's a really kind of crucial question, because I also thought about that when I wrote about the EPPO, the European Public Prosecutors, that this is actually an example where the EU has gone into that kind of idea of federal European criminal law, but I think it's much more defensible, because it's kind of like it's within the EU's own interest, the EU's own budget, it's their own money. It's kind of like it's kind of, I mean, maybe some people think it's controversial, but for me, I can understand why the EU, why you can defend that and why you can justify it, and I think there's justification for it. But it's not that easy in other kind of areas where you're not speaking about the EU's own money and their own interests. So I think that you need a kind of like a much like, yeah, the EU needs to be a different political entity, in my opinion, for this to happen, and also, you know, it needs to be, yeah, and it needs to have a lot stronger political sort of like backing. You know, the EU needs to be transformed to the United States, and I think that's not going to happen in at least maybe our lifetime. So let's, I mean, that's a extremely good points, and I think that's also something that I would have, if I had more time, I would have gone in more to that. I was doing a little bit on federal comparative criminal law and federalization of criminal, but I could have done a lot more of that, and that's super helpful. I decided to raise that. Really helpful, and it's just a good idea for the next sort of piece. I think.
Thank you so much, and I may give you the chance to write that. I'll get in touch later. But now I would really like to open it up to Q&As. So please, you know now since 2020 how Zoom works. So you can raise your hand, turn on your camera, or just turn on your mic. So I would really like to have questions. So you can either type questions in the chat box, or you can absolutely jump into the call. So please, as always, don't be shy, and we still have time. So please.
Oh, Pedro is there. I didn't see you, Pedro. I think Pedro had a question, I think. Yeah, go. I think you can go ahead, Pedro.
Yeah, can I?
Yeah, of course.
May
of course.
I? Yeah, okay.
Please.
Good morning, everybody. Congratulations, Jacob, for the publication of this long-awaited work and book. And thanks to the organizers for having this wonderful session of introduction of the book. So I just have a small point concerning the last statements you made now. I agree with you that criminal law should not be used as it is used now to build up a sort of ethical community within the European Union. Criminal law serves to enforce values, not to create values. So I can completely agree with you on that issue, and I'm concerned and worried to see the course things are taking now. But I wonder whether is there really not a space for an autonomous European criminal law? Maybe there is. For example, does it make sense to you? I don't know if you touch upon that in the book, but does it make sense to you that corruption of EU officials is adjudicated under French or Belgian law and punished with the penalties provided therein? Depending on the place where the Corruption Act takes place. Does this make any sense? Now with, for example, with the officials of the European Parliament, depending on where the money was promised or given, this law will apply. I think it's not only a problem of enforcement and adjudication and the federal prosecutors and so on. It's a problem of completely defining the applicable law. And in this sense, to protect what I would call the European Union institutional legal interests, as they were called in the first place by Giovanni Grasso. I think that in that sense, maybe the EU, not under the current treaties, but maybe the EU should have an autonomous competence to legislate and define. But I would like to know your opinion upon that, and that's why I call the idea of responsibility
I
to
think
explain
that's,
this difference.
No, Pedro, I think that's a very good point. And I actually, I didn't touch upon that. I reviewed an article recently on that, actually. I do actually agree with you that when it comes again to, sort of core sort of European interest, like where we're really dealing with, this is actually something which is kind of like, in a way, yeah, and it's also like European, it's so strongly connected to the EU and their institutions. There is, I think, a space and a good argument to be made that there should be more like maybe autonomous criminal law, but I don't think it's completely autonomous. It is, yeah, in a way it is autonomous, but it's kind of like, it is still connected, I think, to the idea of that this is concerned with, the EU institutions kind of interest, and like they're sort of, it's a very, I would say it's a core, I think I call it in the book, maybe I call it core supranational interest or something like that. But I think this belongs almost to the same category, like what you're mentioning. So I think there is space also for what you are saying, to have more powers to the European Union for that kind of like to criminalization and enforcement and all that in that kind of specific area. I do agree. I think I do agree with you, Pedro, actually, on that point. Thanks for that. It could be also developed in the book, because it's a bit different, I think, this institutional thing that you're saying. So yeah, it requires a bit more like space and a different article maybe, but I think it would also work quite well within the book as well, that example, I think.
So we have another question from the chat box. Roberta De Paulis is asking, how can we address the cultural bias that still characterizes domestic criminal law as the tool exclusively in the hands of, again, state sovereign entities? How can we prevent the issue from becoming an object of populist instrumentalization? So if I read this correctly, can the EU criminal law be used to, for example, serve as a limit to possible populist waves in at the domestic level, for example?
Yeah. I was just, I kind of understand the question, but Roberta, would you have an example of that? Because I was just trying to think of an example. I know Roberta as well. Do you have an example which you were thinking of, so I can kind of like touch, like see, because it was a bit like, I mean, for me, I think it's rather that like, yeah, as I used in the, what my example in the book was kind of like on the, or rather, I'm not sure it was in the book, but I used EPO as an example in the discussion that, on sovereignty, that it is kind of like it is taken, and maybe that can also be by populist. Yeah, that's true, actually, because actually, I think about it, Poland and not maybe surprisingly, that's actually connected. I think Poland and Hungary are not members of the EPPO, and maybe that's not a huge. But Poland will become a member now when they have a new government, and Adam Bodnar is the Minister of Justice, which I know Adam a little bit, and I mean that's a fantastic appointment. So they will probably join the EPPO now when they are actually when they have a new government. And I think that's true, because it is in that sense you can actually use criminal or other criminal law enforcement to deal with a kind of a domestic sort of problem, which is basically corruption of EU funds, which I think takes place to a quite large extent probably in several countries, not only in Hungary and Poland, but it's particularly. I think that's the reason. I think that's clearly, I think, the reason why Hungary and Poland have not joined the EPPO, that they want to be protected from the EPPO having jurisdiction to go after them, because the EPPO is fairly aggressive. Having seen their work during the last year since their inauguration, they are aggressive, and they're really going after the money. They're like a smaller FBI with less power, but they are very fierce. So yeah, I think that's true, that in that way it's not that common, but in that way I think you can use an EU instrument, an EU criminal law instrument, and like a body, EU criminal body, to fight, you know, in a way, you know, populism, corruption, you know, in different states. And I think that's why I think it's connected. So that's why those states have not joined the EPPO. I think it's pretty clear. That's why. And also maybe some kind of sovereignty reason as well, that, you know, EPPO stands for, you know, the European, you know, the most European that we have. So we are, of course, we're not going to join it if we are like populists and, you know, yeah. So yeah, it is a good point, and I didn't actually explore this that much in the book, but you can probably explore that in a research project, perhaps. Yeah.
But if I can jump in, I think that this is very interesting because, again, we always thought, and we still think of the EU as a technocratic, moderated kind of actor. But then the more democracy you basically push into that, you may end up, for example, a worst case scenario for some, you have populist parties winning the European elections all across the continent, and then you will have a democratic legitimacy to enact a populist criminal law, populist EU criminal law. So that's an option. So paradoxically, the more democracy, the more we are at risk of not seeing the EU only as a technocratic, harmonizing, coordinating, and even moderating actor when it comes to penal policy, but potentially also a driver of penal populism. I'll stop there. Of course, this has not happened so far.
No, but that's true. You're right.
Of
course, it could happen. You know, you don't know what happened in elections. You're right. That could actually happen. And I think yeah, you're right, I think. I think there was another question here by Clemens wanted to ask a question, I think.
Yeah, Clemens, please.
Yeah.
Clemens is our colleague, of course, teaching and researching in EU law. So,
but with very, very little knowledge on criminal law. So I'm kind of, you know, not really having a question and very little knowledge on criminal law. So I'm not sure where I was going with this. But you mentioned Stephen, and when I think of Stephen, I think of EU citizenship. And in a sense, I was wondering about, you know, if we think about citizenship, one of the problems is, do you need movement at all? Or, you know, where's the limit to this if we think of cases like Zambrano? Now, I was wondering whether you can really have some sort of an integrated criminal law without also having, without also embedding the national system. I'm thinking of, you know, again, one Hungary and Poland, if you have a rule of law problem, it undermines possibly the national system, but then you give them tools to some extent to take advantage of, you know, European arrest warrant or things like this. I wonder if you then have an umbrella of fundamental rights over, can you really have you know, some sort of a EU criminal law without you know, kind of incorporating or federalizing, if you will, the national system as well? I mean, does it really work if you have a slim EU law which kind of, you know, gives access to, under certain circumstances, to the domestic system, but then you work with the domestic system, which is in some places corrupt, and we don't know what you know, further enlargement brings, where you get probably also a different culture. Does it not at one point become a problem? In other words, can you have a fragmented nation?
No, I mean, you can't have a well-functioning, I think, and I think that's a very good question. But I think it also goes to, I think, my idea that the EU is actually not the right forum to solve this question. But you're right in the sense that you can't have a well-functioning EU criminal law without also, you know, integrating national systems, without having a more federal system. In theory, the best EU criminal system would be like completely federalized. You know, that would be the best, you know, in theory, system. But I mean, that's not what the EU, I think, is about. And I think that sometimes people misunderstand what EU is supposed to do. And well, maybe it's also because I have my idea what the EU is supposed to do. And I think EU is supposed to, you know, resolve collective approach. I don't think that EU should resolve all problems in Hungary. For example, you know, just to bring that in, I mean, that's not the EU's kind of rationale. I mean, they can be challenged on that point, of course, but they are not the United States. And they are not like, in the same with, you know, the war in Ukraine. You know, it's the same. Like the EU doesn't have an army. You know, the EU doesn't have all that, and it's not supposed to resolve those kind of like, you know, those kind of those problems. I think it was not designed for this, and it's not been. I think it's supposed to, you know, solve, you know, different collective action problems, but EU cannot, you know, it will never have the powers to help to shape people's, you know, political futures and democratic futures. They will not have that power. I mean, unless they become federal. And do we really want that they become federal? I'm not really sure. So I think that, and I always thought about that. If you go to Hungary, Poland, I mean, EU can do some things which they are not doing at the moment, which they really should do, but they cannot, you know, they cannot make the Hungarian people elect, you know, a different leader. You know, they can't, like, you know, they cannot do it. I mean, so I think that I always see like that the EU has a more limited role, and I think that's what that's my point of view. I mean, some people would probably feel that the EU should have a stronger role, but if you want them to have that, you need to take the next step, and you need to go to what you're saying, to more like a federal, you know, EU. And I think that's where I feel more uncomfortable somehow, but I'm maybe not that imaginative in my thinking.
No, I think I agree, because I was just thinking when you said it at one point, I think you mentioned this in the context of the public prosecutor, when you start to inject certain elements of a federal system into a system which is not,
yeah,
I think then it becomes dangerous, because you know, and at the very beginning of your talk you said, you know, criminal law is the law which kind of affects people the most. Yeah. And I think if you then pretend, you know, you have a fiction, you have a federal system which you are not, and you can't really follow through in terms of protection. I mean,
it's
like,
difficult with the EPPO, and it's a problem. And I mentioned in the book that, you know, the EPPO, they're not sufficiently strong guarantees towards EPPO's, for example, decisions. And, you know, you don't have access to, for example, the EPPO regulation, for example, doesn't give access to judicial remedies in the European Court of Justice. They're only like national remedies. And, you know, the EPPO wants to like be sort of, the Commission EPPO wants to get rid of all judicial avenues for challenging their decisions. And that doesn't work, because they're a prosecutor, and, you know, a prosecutor's decision needs to be able to be challenged. You know, that's kind of like a part of like a fundamental part of rule of law, you know, that. So I think there's a tension here for sure, that, you know, they have this federal, as you say, the federal sort of powers in the EPPO, but it doesn't have the same kind of guarantees to kind of like to compensate for that for the individuals. So I think you have a real problem here, I think, which you can see actually now with EPPO. Yeah, very good point.
Thanks very much, and very interesting talk. Thanks very much.
Yeah.
Excellent. Thank you very much, Clemens. So I think that we may have more time for one or two final questions. So again, you can either write in the chat box and I will read your question out loud, or again, you can jump into the call, turn on your mic, your camera, or your mic alone. So again, please don't be shy. We have Jacob with us for a few more minutes. So
yeah.
I'd be very happy to take one final question.
Yeah. I think people can be a bit shy because it's still like, you know, a bit like niche area. I'm trying to make it more attractive for more people. That's why I'm writing the book, and I'm trying to like reach out a bit more to other disciplines and EU law in general. But it is a bit like, I understand that people feel a bit like almost scared about this area, because it is a bit like niche and technical. You need to know a little bit about the field. I think that's why people are a bit struggling with it. Also maybe asking questions.
You know, the book is really thought-provoking and provides plenty of food for thought. So we have Benedetta Regini, please.
Yes. Hi, thank you for the insightful discussion. You're right, it's a niche topic, but I'm a PhD researcher in European criminal law.
Oh, great.
And, yes. But I was wondering about the discussion related to the autonomous and the fact that the EU cannot achieve certain, they cannot pretend to, I don't know, impose, for example, to Hungary to do certain things. Yeah. And I was thinking about the case that there is now in Hungary related to an Italian citizen that is shown in the trial, like with the very...
That's absolutely insane. I've seen it. That's absolutely insane. Yeah.
but in this case, I think the EU has the Article 2, which is the fact that we are an EU of values, and I think the values are also embedded in criminal law, and like criminal law embeds certain values of the EU. So I was thinking, to what extent you can say that the EU should not arrive to this, because it's not, if not, it's going to become a federal system. Like,
I know. So I think the argument here is that if the EU used common values, for example, as a justification, they can do everything. Then they are not anymore like a supranational organization. Then they are like a super state. Because I honestly, like the values clause, Article 2, I know it. It's extremely broad. Like you can really do everything with it. It's like you would open a catapult to actions, and I think that's it's really upsetting what you see. It's really it really goes to the heart of you. Why cannot the EU do anything? But it's because like you have the EU is not it doesn't have that kind of legislative power. It doesn't have that legitimacy. I think that's the problem. The EU doesn't have the legitimacy to take that action. It doesn't have that political sort of democratic sort of backing to take those kind of actions. It doesn't have that strong sort of democratic sort of a narrative, and the institutions that make it that it can represent all the citizens in the EU in that way, that it can actually take actions in a separate state in that way. So it needs to have a much stronger democratic legitimacy, which it can only get by becoming more federal and becoming getting rid of council of ministers. How do you see EU become more federal? Well, then you have to get rid of the states representatives. You need to have a full European Parliament, which would be the only kind of representative, and maybe you have still the Council of Ministers, but it would be a completely different kind of setup, politically. And if they have that setup, I think you can also, take actions which are kind of generally not, within kind of the traditional sort of space of the EU, but rather within the states. And then you can also more autonomously act to handle this kind of situation, which is completely horrible. But it's just, I don't see that the EU is that yet, and it needs to happen something politically for the EU to become that, I think. But it's a very good question, and we have many scholars in the field that are more arguing the line like you are doing. So you're not the only one. You're not the only one.
I'm a very utopistic person about the action of the European Union, especially in criminal law. I think that's why I'm still disillusioned. I'm still illuded that there can be more to do, that there is more to do, and there is more to expand the field. But I think you made a very good point about the expansion, because effectively it's not the competence of the EU criminal law to teach values to the member states, and this is absolutely true in my opinion. But from my perspective, is always why the EU should not act more, because transnational crimes and similarities, at the end, it's more common to have people who goes from one country to the other and commits crime in another country than to have national crimes nowadays, in my opinion. And so that's my utopistic view of the EU action.
Actually, with the Hungary case, with that, actually there might be a cross-border element which actually would make EU sort of criminal law relevant, because I'm actually not sure that this could be consistent with all these EU directives that I've been mentioning here to do that. So I'm not, maybe there is even an EU criminal element here that's relevant in this particular case. I actually haven't thought about it, but I think there is a strand of scholarship definitely going in this direction. I know that my colleague Irene Vicesorek is definitely arguing more towards a more value-based, for example, EU criminal law. Still a bit going from the same point of view that I started with, but more progressive, I think.
Excellent. So I'm, of course, especially delighted for the contributions by fellow Italians. So of course, I was also delighted for Benedetta's question. So unless there are any last minute questions, I think that it's time to wrap this up.
Yeah, I was wondering about that. Why is EU criminal law so popular in Italy? Because you know, it's I mean we also, when I was in the ECLAN conference in Liverpool a couple of that's in November, there's a lot of Italian, you know, younger scholars as well.
I think I can answer. I mean, there were books published in Italian since the 1980s. I can easily think of at least two big monographs published in the 80s, and then more recently. But yeah, historically, it's always been like, it's a niche topic everywhere. But in Italy, I have to say, again, as someone who hasn't been working or doing research in Italy for the previous 15 years, so I have no dog in the race. It is historically a not so niche topic, to the point that, again, we have PhD programs and courses in EU criminal law, unlike other and many.
No, I mean, like, I know that there's, there's definitely, you know, there's Leandro Mancano, it's like there's Lorenzo Grosso, Stefano Montaldo, there's several people I'm working with, I mean, that I'm working with different projects in, and they're all like they're like, it's kind of like there's a bigger proportion of Italian than any other nationality.
I would encourage more Italians to write in English about this topic, so their voice can be heard more widely. I think that would be the recommendation. But again, so to wrap this up, it was great because, again, at QEB here in Belfast, even though this event took place virtually, we had been dealing with a lot of EU-related topics, but mostly, as Billy can confirm, Brexit-related over the past few years. So it's really been kind of Brexit-dominated, like our conversation pertaining to the EU more widely. So it's been absolutely delightful and refreshing to have this conversation, opening up our horizons on EU law once again.
If I can make a final point on Brexit, I think that actually these are one of the few areas that UK wants to opt back into. Actually, they want to opt back into, you know, judicial cooperation in particular, and Europol and Eurojust. You know, people
increase the criminal record.
Exactly.
So there's space, hopefully, to organize like a panel in the near future, in person this time. So Jacob, thank you so much from all of us, from all the attendees. And again, the book is coming out in June, will be open access, hard. So go get it. It's going to be free, open access. And hopefully will foster even more discussions and very insightful and thoughtful conversations. So thank you, Jacob, once again. And again, thanks to all the attendees.
I'm super delighted, Alessandro. That was so nice of you, and really good, like, talk and presentation, everything. I'm really happy about it. It was very, like, it was a warming event.
Thank you.
I feel very
and again, and it was also a preview, because I think that this is one of the very first presentations of the book. So we are truly delighted. Thank you so much, everyone, and see you soon.
Thank you very much. Thank you.
Bye. Thank you. Bye.
Bye.